Hello. We feel it is important to issue a personal statement regarding the recent FDA investigation associated with Real Water.
All right. Please be seated. Thank you.
All right, good morning, and let's go ahead and set forth our appearances for the morning.
Will Kemp, Eric Pepperman, Joel Parker.
Good morning, Your Honor. Joel Odou, talking on behalf of Real Water Inc. and the Lifestyles.com Inc. and Real Water Both Us.
Good morning, Your Honor. Scott Rasmussen, on behalf of Patent Instruments Inc. along with Orion Planning.
Good morning, Your Honor. Jim Neale, David Spurlock on behalf of UNFI.
Good morning, Your Honor. Jim Kavanaugh with Gordon Reese, Las Vegas, for third-party defendant, Real Water Tennessee, LLC.
Good morning, Your Honor. Rob Robbins, Milwaukee Instruments.
All right, does that cover all appearances for the record?
Yes, sir.
Okay, and I think next up, what do we have? Is it Affinity Lifestyles motion? Lemon?
Your Honor, we're going to pass that motion. The parties are still talking about potentially a resolution of that motion.
I understand. I'm gonna let you do what you have to do.
And then the parties, I think, are prepared to talk about the jury questionnaire. We had that up as some action.
Okay, all right. Okay, where do we start?
Looks like number one, Your Honor. So, with the pleas of the court, I can kind of explain the defense position. We've all met and conferred. It's fairly universal position. So in the jury questionnaire, there's a place for people to check if they can't serve because of hardship. In general, the parties agreed to excuse those jurors. It's a very general matter. In addition, the defense went a step further and we looked at individual jurors as to reasons that it couldn't serve for financial reasons. They may not have checked, in many of these cases, they may not have checked the box that they couldn't serve because of hardship, but they may have said things like, I live paycheck to paycheck, I could lose my apartment, my car, whatever, if I have to come to the trial. Those sort of things that in our view were a fairly clear reason to excuse them. In other words, they, people feel like they need to do their civic duty. They don't want to get out of jury service, but they acknowledge that jury service is going to be a tremendous financial burden on them. And I think in those cases, the defense has said, you know what, we're going to look beyond a particular question, we're going to look at all the questions, and we agreed to excuse those types of jurors. We're happy to do them juror by juror, but we heard the court's comments yesterday. In fact, we're prepared to do them juror by juror. I can certainly comment on even the first one, who is a nurse at a hospice and takes care of people who are very sick. And we felt that was a juror that should be excused. And I think the first couple are either that type of situation or the situations where people have put in the questionnaire something that shows financially that this would be a tremendous burden to them. I would also point out, Your Honor,
How many are there in this field?
1,423 that have completed questionnaires.
Right.
We have, both parties, plaintiff and defendant, have gone through the first 4 weeks and submitted to the court where we agree, where we disagree. Week 5, the defense has provided that to the plaintiffs. They're going to be providing that to the court shortly. Week 6, the parties are finishing today.
Your Honor, I think I can be a little more specific with your question. In terms of list 1, for example, there were 300 jurors. As part of that, the parties agreed to excuse 163. We understand the court's position on hardship.
I don't have positions.
Well, we
I always
understand.
come back, I always come back, I don't have positions. It's recognizing hardships.
Of course, we understand the court's philosophy on that, and we endeavored to reasonably work with defendants. But there were several that the hardship may have been suggested, or there may have been a comment about something, but it was far from clear that they didn't know if their employer paid for jury service while they were out. In some situations, people claim financial hardships where they earn an amount of money per week that I believe to be less than what they would earn serving as a juror, or they had, flexible or different jobs. So it's those that are really at issue. And of the total ones that we disagree, there's 43 under list 1. 19 of those are just based on bias, where the defendants say that the jurors or have some sort of bias. We don't believe it's worth the time and effort it would take to go through the disagreements on those, because the juror bias can be explored during voir dire, and we all know that that's a fungible concept that I think we need to voir dire on that issue. Of the hardships, there's 24. 12 of them did not check the box for a hardship. In other words, they checked the box saying they could make the sacrifice to serve. So whether some of those people may have also indicated elsewhere that there may be financial issues, we think if they're not checking the box and they're saying we can serve, we should at least bring those jurors in. And if for some reason they explain something that they can't, then that's appropriate for voir dire. Of list 1, there are 12 that we disagree on hardship where the box was actually checked. In other words, the juror said, I can't serve because of a hardship, but we disagree on whether that hardship or those statements are enough to excuse them at this point. And with those jurors, we believe they should be brought in. We're not saying that they don't have a hardship. I think the concern there is, there's some questions, significant enough questions that we think it's worthwhile to bring in. So that's the general breakdown using list 1 as an example.
And is there a list 2?
There are 4 lists that we
That's what I'm
prepared
trying
to
to
talk
get
about.
to, right?
List 2,
5.
Soon to be 6.
It's gonna be 6.
And here's kind of my point, because when we specifically deal with the excusal issues, you remember that statutory, right? You had NRS 6.030 that deals with excusals. And 1C is specifically related to undue hardships or extreme inconvenience. And that's one of the things I actually explained this to the panel when I went down there. And I always talk about, mere inconveniences and an undue hardship, and it's not, right? If you look at the statutory rule, it says undue hardship or extreme inconvenience. And there's a reason for that, because, there's nothing convenient about jury duty, right? If we dealt with conveniences, no one would show up for the most part, unless you're retired and you have nothing else to do. That's right. So how do we do this? Because one of the things I don't want to do, I don't want to go down the path necessarily where we spend an inordinate amount of time on this issue. And the reason for it is essentially this. You got a lot of motions in limine and things like that to deal with, right? And so,
Judge, what I would suggest is where they don't check hardship, I don't see any reason to get into it, because they didn't check it on hardship. So you're gonna say that the juror didn't check hardship, but the parties think it's a hardship for them? That just can't be, whether it's either the plaintiff or the defendant. And then I would also point out, as Mr. Pepperman alluded to, there are a lot of jurors who think they may have a hardship but don't know it. And I'll give you an example that you had in your own courtroom. I don't know if you recall, we had a security guard from the Wynn, young girl, she just started. She came on, we asked her, she says, I have to get off because of hardship, all right? And so you asked her to call the HR department at Wynn, and they told her that she's gonna get paid during the entire jury duty. Okay, so she just didn't know that. So she went from being a person who wanted off the jury because of hardship, now she wanted to be on the jury because she was getting paid by the Wynn. And so
unless you got her $40 a day for being there.
plus you got even more money. So, to suggest we could just explore the hardship with a vacuum, I don't know, I know the HR departments of a lot of the big employers, but not all of them, and they could have changed their policies, but to suggest we could just do this in a vacuum because we think that this juror's got a car note coming up, I don't see how you could do that. So what I would suggest is where where someone's actually checked the box of hardship, and there's a debate about it still, let's take a quick look at those 18. I think the first case was 18?
12 in the first one.
12, let's take a look at those 12. Let's take a look at maybe the next set.
22, 34, and 30.
You know, we don't have to sit here and grind them all out today. I think the first 2 or 3 panels were more important. As courts indicated, we can't just stop hearing motions eliminate to focus on this. And you just can't resolve this issue, Your Honor, because there's just not enough
I
information.
mean, typically, not and from the historical perspective, and I don't mind telling you this at all. I mean, in a general sense, where the parties can't agree on certain things, what do I do? I just bring them in, right? Because I'm hoping you can agree on certain things, because if you agree, there's no appellate issue, right? There just isn't.
Yeah.
But if there's some sort of disagreement, then unless I look at it as patently obvious, what I historically have done is bring them in and see what they have to say, and then dismiss if there's a problem.
Your Honor, if that's what we need to do, that's what we need to do, but that is going to be a even longer process than any of the parties I think would desire. There are some that you can see from the questionnaire. Certainly we're not talking about bias, but we talked about that yesterday, and there are some that completed a questionnaire that you know there's a bias problem. And as we discussed yesterday, it's very difficult to rehabilitate someone when they say something that is that off the charts. And I use that as an example because some of these hardships are the same way.
I don't mind saying this. We talked about rehabilitation. For example, someone testified, during jury selection that says, you know what, I just don't like these bottled water companies. I think they're ripping people off, and I think water should be free, and so on and so on. And if they said that, and I can't be fair in this case, plaintiff's counsel could ask him 1,000 questions, doesn't matter. Out of here, right? That's kind of my point, And so we said, and so my point is, I said this, it's like, and that's the only reason I think there's a lot of insight from John Marshall, right? Once you cross that line, no matter what they say, yeah, I can promise to follow the instructions, but the law doesn't trust you under those circumstances. Because you can get someone else to sit in that spot and say, look, yeah, I'm neutral as far as bottled water companies are concerned. And that's the individual you want. It could be on the flip side. Some people don't believe in filing personal injury cases, right? Once they say that, how are you gonna rehabilitate? I've had I've had a few panel members say, look, I don't believe in pain and suffering. I believe you should have your medical bills paid, and if there's any wage loss, that's it. You don't get more. Some people don't believe in judging others because of religious reasons. I mean, the list goes on and on. It really does. And as far as the batching, do we have any batches ready?
We do. We have the first batch ready to go, juror number 1, if that's what we need to talk about. But I think the court has hit upon the issue, and it's the same with hardship, the same with bias. If somebody says, I'm going to lose my house or my car, or there's nobody to watch my children, and they still didn't check the right box, that to the defense seems like an obvious one where they should be excused. They may not have checked the right box. I don't hold that against them. I don't need to call them down here.
Yeah, it's the first time they've ever done a jury questionnaire. Do they know each box to check? Did they figure that out? That's not the easiest thing to do.
I understand, but is there a list or something I can look at, or copies of it?
There's a parties combined excusal list that we have. We can certainly give that to your court right now, so you can go through as we're going through them as well. I have it in paper form if you'd like that.
Your Honor, I have a copy of the parties combined list for at least list 1 that we can look at if that helps.
I just wanna see what you have, and we can make copies if we have to show it. This one
It's
is
the same thing I have. Yeah, we have that.
This is actually what we done, where we did it, I'll say that.
Well, this is a combined effort with guidance from their JEA on it.
So we have the agreed upon excusals on the list, right?
We do.
The highlighted are the disagreements. And so, for example, if you look at the first one on the list, 0005, this juror checked the box that he's able to serve as a member of the jury. And the defendants argue a medical hardship on behalf of this juror when the juror has indicated that he would be willing and able to serve. So we don't think it's certainly on these ones, these disagreements, it's worth going through them to decide whether or not the parties are imposing a hardship on a juror who's indicated he or she's willing to serve. Even the ones where they have checked the box where they are saying they're unable to serve, certainly there are maybe some of those that we disagree with who would have a real hardship, but a lot of them there are questions. You know, for example, like the example Mr. Kemp gave from the endoscopy case, and I give a lot of credit to my staff and other attorneys in my office who have been greatly taking the labor and lore on this, but I've looked at some of the jury questionnaires, and one of them was a TSA agent who checked the box that they were unable to serve because of a financial hardship, and that they would not receive their regular pay, and that they would actually have to reimburse the jury fees to their employer. And that seemed odd, and we looked at that, and the TSA's policy actually is to pay the juror for their regular wage for their service. And then because they're paying them their regular wage for serving as a jury, they have to reimburse the jury fee. So they don't get the jury fee in addition to the regular wage. So that was just confusion, and it's those types of things that we think, there are questions. We're not 100% sure that there's really a hardship here, and we think those, could be brought in to explore the hardship a little further before we agree to excuse them. That's the only position. And so whether it's worth our limited time to go through those disagreements, we'll do what the court thinks is best.
Your Honor, the difference, I think, is going to be about 240 additional people that will show up on the 5th as a part of this, based on what we've seen. Now, I'm counting the last 2 boxes based on the average of how many people we don't have an agreement on, but that's 240 people that we're going to have to deal with in the first week of trial on hardships that they've claimed, not claimed, medicals that have claimed or not claimed in the matter. Some that had English issues that they didn't check the box.
Are there any communications issues that have been apparent based upon the box?
Yes.
Yes. But that doesn't mean that they know how to, that they, because of their issues, don't know to check a particular box based on the instructions because they don't understand the instruction.
Or they're in a hurry.
Or they're in a hurry, yeah.
But generally, those aren't disagreed to. If it's clear they don't speak English or they say, I can't speak English, then
And that's
we
true
agree to
too.
excuse them.
But we've got 240 more people that'll show up on the 5th, unless we want to do something right now. And we don't have to do that right now. It's going to be your call, but it's not like the defense went in there and said, look, like the first one, the medical hardship, person suffers from liver disease, they're not gonna be in here. Number 5,
Why,
don't worry, they won't be here.
why not? Why not?
Well, there's
Yeah,
always,
why not?
not only hardships, there's also preemptories, isn't there?
No, that comes later.
I get that, they're not gonna be in your jury.
That comes
We
later.
don't know that.
Okay.
We have no idea.
People suffer from liver disease.
All right, well, anyways,
That's like saying
they
somebody
said
had a
in their
jury.
thing, they can't serve, they have a hardship because they have liver disease.
Yeah, I don't see all that. That's like saying anybody who's been in a car accident can't serve on a jury in a car accident case. That makes no sense.
Didn't try to say that.
Okay, but anyway, it's obvious we don't agree.
Right.
There's one thing for sure, we have agreed on a lot.
Yes, we have.
Okay, I mean, and so it's been fruitful.
Agreed.
Yeah, it's been fruitful. Okay, anyway, I'm looking at this list, and this is what I think we'll do. First and foremost, we might as well get rid of those that we've agreed to, right?
Makes sense.
Yeah, I think they've been told.
Right,
Most of them.
makes sense. You know, and so I just want to go through the list and make sure our clerk, and we have the appropriate record, and I'm going off page 1. And it appears to me,
Well, Your Honor, on the agreements, we've already submitted those to the jury commissioner, so the
Yeah.
jury commissioner could advise all the jurors you've been excused.
so like, for example, panel member 6, 017, that's been already issued to the jury commissioner?
Yes, all the agreements we've submitted on all 4 of these lists to the jury commissioner, so the jury commissioner could advise the jurors they've been excused.
And for the record, for now, for example, panel member 039, I guess that would be, looking here, number, I guess juror number 13, have they been excused? No?
Nope.
Oh, so Your Honor, if there's no indication, that means that they checked no hardship box, they said they could serve, and neither party thought there was any reason to excuse them, so they're on the list who were scheduled to come.
So as far as scheduled to come, interesting, I'm kind of getting it now. As far as scheduled to come, for example, when I look at panel member 85, I guess I should say panel member 26. Out of all these listed on page 4, she's the only one that would be.
No, Your Honor, so like the one right above, the parties did not reach an agreement for 25, so 25 would show up. 26 has nothing there, so they would show up. 27 is the parties agreed to excuse. 28, the parties agreed to excuse, and so forth.
There are only 2 on that page.
Okay. Well, that's kind of my point, that's what I'm trying to get at. Trying to.
But that, I think that page is a bit of an anomaly.
Okay, but I mean, for example, I looked at page 2, it's kind of like the same thing. 2 out of, so out of, I guess, 1, no, I guess it would be, is it 2 on page 2?
Page 2, there's a bunch the parties don't agree on, so those people would come in.
Right.
I count 6 on page 2 that would come in, Your Honor.
Do you? Let me see, I want to make sure I understand this.
If barring some ruling from the court excusing the disagreement.
Oh, no, that's my point. Now, if I ruled on all 6 without them coming in, only 2 would come in? off the page
If you agreed to exclude all 6 on page 2, Your Honor, there would be 2 on that page.
Yeah, that's kind of what yeah.
Yes, sir. And I think that's why the jury commissioner was adamant about summoning so many.
Well, we've had, I just want to make sure everyone understands, we have, all of them don't come in.
Right.
Right.
The first day, we kind of roll them. And I don't think I've done it in this case. But I've had a case where I've had another 500 in my pocket, right, Mr. Parker?
That was our 5-month trial.
Yes. or I had to declare mistrial, I had another 500 lined up just in case. And they thought that, that what are we going to do? And I instructed everybody, we're gonna come in tomorrow with the jury questionnaires, because I have another 500 lined up to come and fill them out.
Actually, that was the case I had against, Will Parker, Randy Dillon.
Yes.
That's right.
And why? Is because we had to get a verdict. Right? That was the first, wasn't that the first subclass?
Yeah, that's the
That
first
was,
one.
that was.
Interesting. All right, I mean, so, you know what we'll do? I don't want to spend, and I will commend everyone. You've done a wonderful job on this. What I'm going to do with the first batch, before I make a final decision, but I'll make a decision very quickly, within no later than Monday, but I want to take a look at the questionnaires and kind of go through them a little bit and see kind of what's going on, because clearly I don't have to worry about the ones that have been stipulated, because you've already contacted the commissioner. I understand that. And so I want to kind of look at them and see what's going on, because I don't know what I'm going to do with this. I might bring them all in this. I don't know. But I have to see the, I need to get a feel for the questionnaires and responses. Sir?
Thank you, Your Honor. Just one, I guess, add-on, if you will. The parties have received emails from Lynn as to people who have provided travel excuses or other excuses and submitted those via email to excuse them. I don't believe they are reflected on these lists because those come in every week. And so it's possible there could be somebody in batch one that the parties have agreed to excuse via email.
And the only issue with Lynn, she's not here today. Normally, I could bring her in and she could tell you what's going on.
Your Honor, I have a list of those juror numbers that we've agreed to excuse via email. It's not formal or anything, but I can provide it if that's helpful.
Yeah, we can get it. And would some of those be in his first batch and the second batch? And so on?
Yeah, I believe there are, Your Honor. We got some even this morning.
It's not in a list I have, I don't think, it's not in chronological order, so it's difficult to. What we noticed is a lot, because of the reasons why you're unable to serve didn't include travel plans, some people didn't check the box, or they checked the box, I am able to serve, because travel plans weren't listed, and then submitted travel plans later. So that's the most common situation where they check the box where they're able to serve, and then they submitted travel plans, and then they were excused. So there may be some of those. That's why I have this list here, just to.
Can we make a copy of that?
I have an extra copy for the court, and I have one for defense as well.
Yeah, that's fine. Just one page? Oh, it's a couple pages. We'll get a copy made.
Can I have pressure on?
Yes, you may. And I'm just going to tell everybody what I'll probably do is I'll take a look at the first batch, or list one, is that what we're calling this?
Yeah.
And I'll go ahead and compare them to the questionnaires and try to get a flavor as to where exactly where we're at and what the disputes are. Because it clearly, it's pretty good as far as explaining the disputes. Then I'll have to make a decision. I'm not know what I'll do yet. But I have a much better idea, because I don't think I can make a decision without having a jury question in front of me. Right? Okay, let's go to in limiting motion.
You have, we have all of the juror questionnaires here, just
Don't
on.
we have them too? We have them.
All right, we've separated them out to ones that are not agreed to. So we actually have the actual ones, which you, otherwise you have all of them, right?
We have them.
Or it's up to you.
I'd rather have your list, your box, because I know it's organized.
You'd rather have mine?
Well, I think it's in order, right?
It is.
Yeah, I'd rather have yours versus.
Well,
Can you show
I'll
them?
give it to the plaintiff to look through on the box, and these are the jury questions. These are just the one, there's 3 boxes of them, the ones that are disputed. That's the best way I can say it.
Yes.
And we can just give those to you, and then if you'll get it back to us by Monday, we're good to go.
Yeah, we can do that. Mr. Pepperman, is that fine, sir?
Whatever's most convenient for the court, I'm happy to look at the boxes and.
Yeah, there's 3 of them, and we brought them down.
And we'll make it Tuesday, because I might be working on Monday also.
I'm sorry, I didn't mean it to, I don't give the court deadlines, I just,
No, I mean, well, here, my point is this, we all have so much on our plate. It can only be, only so many hours in the day,
I
right?
agree.
And I understand. Yes, oh yeah, thank you. I'm gonna give it, Tori knows that I better give it to her. And what you can do, make extra copy to her. And that way, if I'm looking for it and I can't find it, she'll have another copy. And just make a couple copies of that one. All right, so I know what the issues are. Now, where do we go from here?
Eliminate 6 for real water.
Yes, Your Honor, we are, and
Motion in limiting number 6, real one.
I can actually catch the court up a little bit. Motion limiting 4 was denied as moved. 5 is moved and denied.
So we're at 6, right?
So we were at 6, and Mr. Kemp and I were talking, and he has convinced me, and I agree, that 6 is now moved and does not need to be argued.
Are you getting that? You getting those down? Because
Okay, so that takes us to.
And 7 was granted the other day. 8 was denied. 9 we agreed to submit, and we were going to talk about 10.
okay.
And this actually, I'll be very clear, all the real water motion limited will be very brief today. So, whoever's up after me should start getting ready. Motion limited number 10 was to exclude pathology reports of non-plaintiffs in this case. We have, one of the pathology reports concerns Captain Ryerson. That's not an issue here. It's pathology reports of non-plaintiffs such as Miles Hunwardson, Bruce Barnett, and Henry Chickadee. My name gets destroyed all the time, and I probably just destroyed his, so I apologize in advance. DeQuante. I'm going to write that phonetically, so I'm messing it up.
Etiology.
Thank you. We just think they're confusing, they're relevant to this case, and they're not necessarily for this case. And, should be excluded, and that's all we're going to make on that one.
Thank you, sir.
Can we start with the Burke article, please? Do you have it?
Ms. Faria? Thank you.
Your Honor, this is the Burke article, which again is by the Loma Linda people, and it's been pre-admitted. And so what the Burke article did is they, these 3 doctors looked at 4 specific real water cases. They don't have the names here, but we've identified all the names and we provide them, everyone in the courtroom knows who these 4 cases are, except Your Honor. But in the back of the article, can we go to the very back, please, Chris? The back of the article, they produced a series of 6 slides. We blow that up a little bit and maybe the. So what happened here is Loma Linda, for these 4 particular patients, they did liver biopsies of each one of them. And in the typical case, we do not have liver biopsies. There are very few liver biopsies in the group of plaintiffs. For example, we represented 64 plaintiffs. I think we have liver biopsies for maybe 8 or 9 of them. We have them for both the transplant cases, of course. We have tissue blocks for those. We have them for the death case, Mrs. Ryerson. In the cases we're being tried, we have them for Mr. Yu also. Okay, so what we did is we took all the tissue samples we had, and we've gotten some of them since the expert deadline. So we took all of them that we had, and we sent them to our pathologists, and we asked them, hey, would you look at what they're finding in these? We do some research on the type of pathological injuries that you see when people ingest hydrazine, and we see if there's something you're seeing in the slides. You know, so what we were, you know, to be honest, we were looking for a unique mitochondrial deformation that was caused by hydrazine, which in past cases, like the Reslin case, we have indeed found that kind of unique mitochondrial deformation. We did not find that in this case. But what we did find was similarities that are suggestive that the liver injury was caused by hydrazine, but not definitive. It's consistent with hydrazine toxicity, but it doesn't conclusively establish that it was hydrazine toxicity as opposed to someone else. So in any event, Dr. Datno takes this group of slides, and then we get to his report. Let's have his report, Chris. So here's his report. As you can see, and Dr. Datno is a pretty prominent pathologist from San Diego. We've used him. I think he might actually have testified in front of Ron before. But in any event, so Dr. Datno, he looked at the Burke article, and up a little bit, Chris. He looked at the 6 slides that they're established. I'll go down. Go to the next page, please. Are we on the next page? Okay. And then he reviewed each one of the cases, and he compared the findings on liver biopsy. First of all, in the U case, because like I mentioned, you did have a liver biopsy. So he compared the findings on liver biopsy in the U case with both what he had seen in the Burke article and what the literature suggested. And so finds the same thing, you know, and the big one, I think, is bile duct proliferation and ballooning degeneration. Those are pretty odd things to see in an acute liver failure case. And of course, the theory is that when the rocket fuel goes down into the liver, it's got to be discharged somehow, so it goes out through the bile ducts. The bile ducts, of course, are like tunnels, thousands of tunnels surrounding the liver, and that's how the bile gets out of the liver. And so that is where you would expect to see the damage. I mean, hydrazine is not an acid, but using acid as an analogy, if you have acid going over a bile duct, you're going to get problems with the bile duct. And this is what they saw in Mr. Yu. And that's why we think his testimony is relevant comparing Mr. Yu's case with these other 4 cases. And let's see the next one, please. This is Taquante Henry. He's one of the 2 liver transplant cases. His trial, I can't remember if it's set for next April. Stick with Taquante. Back down. Back down. Well, okay, this is good. Let's stay with this one. It's okay. So bridging necrosis. Bridging necrosis is not a typical finding for someone in their 20s like this. You know, you will find it in say someone who's been an alcoholic for 40 years, but bridging necrosis. So this is what they find, and again, he compares these slides back with the, let's go back to the first one. I think the first one might be a better example of what we're trying to put up. First one first, down, no, up. Okay, right, up, right there. Okay, so, no, keep going. All right, I keep going. Let's go to the next one. Okay, this is Bruce Parent. He's another one of our clients. He wasn't part of the Burke article, but he's someone else who had a biopsy. And again, you see right there, bile duct proliferation, ballooning degeneration. You're seeing the same things on all these patients. Let's go to Mrs. Ryerson, please. This is Mrs. Ryerson's down or up, I guess. Okay, same kind of findings, Your Honor. Bridging fibrosis, bile duct proliferation. Let's go to the next one, please. This is Mr. Hunwartson. Mr. Hunwartson was a liver transplant case who was set down for trial in front of Judge Kishner in January. He's the lead plaintiff in the case. It's commonly referred to as the Hunwartson case. So he had a liver transplant. I mean, he barely made it in the hospital. I think he had like 0.5% liver function when he got there. They had to do a flank for life here. His father was a steel worker, and they jawboned the when they had an emergency flight down to the hospital. I mean, helicopter didn't move the roof. Just happened to have someone die like an hour before, and they grabbed the liver. So this guy's lucky to be alive. But in any event, they have tissue blocks of him and Taquante, and also Mrs. Ryerson. So we looked at those. This is what we see again, bile duct proliferation. Now, Mr. Hunwartson's case is a classic case of a prior incident, Your Honor, because he drank real water back in, I think it was 2018 or 2019 off the top of my head. But he is prior to most of the plaintiffs, prior to all the plaintiffs in this case, except maybe Mr. Belsky. He might even be prior to Belsky. So this is definitely a prior incident. So the argument being made here is that we can't have medical testimony of a prior incident that shows what the typical injury of a real water victim. I just don't think that's a credible position in Nevada case law, especially when we've got a medical doctor who looks at this. And I would point out that when we filed Dr. Datnow's report on March 24th, at least one of the defendants had their own pathologist look at what he had done. And they chose not to have an opposing pathologist. So he is the only pathologist in the case at this time, Your Honor. Real Water doesn't have a pathologist. I mean, none of the defendants here have designated a pathologist. And what that tells me is that they don't think the testimony can be refuted, or they come in and refute it. But again, so these slides are intended to provide support for his medical opinion, specifically on two of the plaintiffs in this case, Yu and Ryerson, that their pathology findings are similar to the pathology findings in both the Burke article and in the prior cases, specifically Hunwartson and the others. And so for that reason, we think we don't see any basis that this can't come in. You know, on some of the other prior incidents, they argue, oh, Judge, you can't let a prior incident in unless you have a medical doctor. Well, here now we have a board certified pathologist. They still don't want the prior incident in. So for those reasons, Your Honor, we think the motion should be denied, and Dr. Datnow should be allowed to testify about these tissue slides and his findings.
Sir.
Thank you, Your Honor. You just heard the reason why this should not come in. Plaintiffs' counsel just argued that Mr. Hunwartson is lucky to be alive. That's not evidence that should be in this case. Plaintiffs' counsel makes a big deal about trying to bolster the opinions of Dr. Datnow. What I didn't say, or what Real Water didn't say, is that they're challenging those opinions. So if Real Water is not challenging those opinions, why do those opinions need to be cumulative, bolstered, and why does this prejudicial evidence need to come in? It doesn't. The Burke article, that's already into evidence. So there is no need to have these other plaintiffs in other cases prejudicial testimony as to Real Water to compound the damages in this case. This testimony is not necessary, it's cumulative, it's prejudicial, and there's been no challenge. Plaintiff just pointed out, there's no other pathologist to challenge Dr. Datnow, so that testimony is going to be unchallenged on that basis to the jury.
Here's my question. Is there any issues regarding Real Water consumption, ingestion, or anything like that?
There will not be from Real Water, Your Honor.
Yeah. And as far as these individuals?
As far as the plaintiffs in this
I'm
case.
not talking about as far as the,
Oh, in the other cases?
yes,
So no, we haven't got the expert disclosures in the other cases, Your Honor. Again, Mr. Taconte had a liver transplant. The prejudicial effect of that in this case is immeasurable. It's like saying, you know, look at the magnitude of these injuries in these other cases when you award damages in this case. It just doesn't belong, Your Honor. It's clearly a case where, or a situation where the prejudicial nature of the evidence outweighs the probative value because there's not a challenge as to the evidence to begin with. And for that reason, it should be excluded, Your Honor.
well, here's kind of my point, and we're talking about other issues, and I remember one of the minute orders in this case, there were 6 factors I was thinking about that potentially should be applied, and I looked at the Krause case, Andrews versus Harley Davidson, and the like, and one was there a nexus between the similar events and the product at issue? Is the evidence relevant to plaintiff's claims for relief? Whether the minor differences between the similar events and instant case warrant exclusion, the type of harm that could result from the defect, whether similar events are supported by direct and or circumstantial evidence, and if a jury could reasonably draw an inference that the product was a product defect occurred. And I took that, and I mean, none of the Nevada cases came out and said that explicitly, but implicitly, when I was rating them, are some of the factors they relied upon. And so, with that, and I've already issued a decision on that. Tell me, why wouldn't this series of biopsies and opinions of the pathologist, right?
Yeah.
Would they come under that rubric, or no?
They would not, Your Honor. The reason why they would not is we're talking about damages. In those other cases, those other situations, we're talking about causation. Here, the issue is one of damages, and again, Dr. Datnow's testimony will not be challenged by real water as to the liver damage suffered by Kathleen Ryerson. For that reason, it's different, and for that reason, it should be these other liver injuries, which are subject to discovery in other cases, subject to other expert opinions in other cases, should be excluded. Their probative nature is no longer relevant. It's not probative of anything. Again, Dr. Datnow says Kathleen Ryerson's liver injury is consistent with hydrazine poisoning, and that testimony is not challenged. Why do we need these other cases to bolster that opinion?
And the reason why I asked that, for example, is my recollection in Harley Davidson, there was a comment made by the Supreme Court as it pertained to another vehicle collision. And I mean, it wasn't a holding of the case, but the Supreme Court did say, well, you know what, that one probably should have been kept in too. And it's my understanding that specific event was slightly different, but nonetheless, it should have come in. And then we have the Krause case, that involved the ladder and the lever, right? And they let that in.
And
You know,
the difference
circumstantial
is-
evidence, yeah.
The difference is here, the lever is not an issue with real water, and the motorcycle defect is not an issue with real water. So once you remove that piece of it, now we're talking about damages. And that's why it's prejudicial nature when they start talking about the damages for the plaintiffs in this case, and they start talking about the damages of plaintiffs in another case. That takes us out of Krause, and it takes us out of Harley Davidson, and it takes us in the area where its prejudicial nature outweighs its probative values. It's like saying, well, Mr. Hunwartson is lucky to be alive, therefore you, the jury, should award damages.
Well, I just want to say this.
You know,
Whether that comes in or not, whether he's lucky to be alive, that's another issue. I just want to layer that a little bit. You understand what I'm saying? 'Cause,
I do.
yeah, you get it. But no, go ahead. I don't want to cut you off. I just
No,
wanted to know.
Your Honor, and I'm glad the court appreciates the humor in it, because it is, right? It's a little bit too far. And so the question is, again, the court's
Well,
only balls and strikes, and what do you call them? a ball or strike on this one.
Right, but my point was, I just want to make sure, I see a distinction between potentially findings found by a pathologist versus arguing to a jury that, yeah, this victim's lucky to be alive.
Right.
That's what I'm saying, that's a different issue.
It is a different issue, Your Honor, and the issue in this case is the pathologist's testimony is not being challenged by real water. And so the question is, how is this cumulative evidence now, or it's not even cumulative, it's just prejudicial evidence. How is this relevant to any fact remaining in the case? And it's not, Your Honor.
All right. Mr. Kemp, as far as I was somewhat not being fair to you, I brought out those factors.
Yeah, Your Honor. He is lucky to be alive. I didn't intend to say that in front of this jury.
I understand.
Okay. And with regards to not being challenged, I mean, how can you say it's not being challenged? He hasn't stipulated to liability and causation on these 7 cases. So he wants to say he's not going to challenge the pathologist, but he's going to argue to the jury that it could have been this other factor causing it. Particularly in Mr. Hughes' case, I mean, where they're trying to say he's an alcoholic because he used to go to, he drank a lot in college 20 years ago. So how can they say not challenged? If they're not stipulating to liability, it's being challenged. And that would be all the defendants, Your Honor, with regards to this. Because this guy is, the doctor, Dr. Datnow, is expressing an opinion that these injuries he is seeing is consistent with hydrazine toxicity. Okay? That's his ultimate opinion in the case. Not determinative. Okay? I don't want to mislead the court. He's not saying that this conclusively proves that hydrazine toxicity causes it.
Well, I understand that, and he's not required to do that.
Yeah, so in any event, Your Honor, unless Mr. Odou wants to say that he's stipulating liability on the 7 cases, you know, he's still arguing that Mrs. Ryerson wasn't caused by real water. He's still arguing that Mr. Yu isn't caused by real water. Just saying he's not challenging the pathologist, what's that do in terms of making this evidence not relevant, not appropriate?
Well, Your Honor, I believe we're getting a little bit ahead of ourselves, but we've said that we're not challenging this testimony. And as to the issue of the stipulation, that'll be for next week.
Well, what do you mean a stipulation as to what?
Well, at least an offer of one.
Oh, okay.
Whether or not the plaintiffs accept it,
Well,
that's a different issue.
That's an issue. Right.
but I can definitively say that real water is not challenging the opinions of Dr. Gatner. And I can definitively say that real water will not argue that Mr. Q's injuries were caused by alcoholism.
Here's my last question, though, as far as, and how many, is it 2 or 4? What's the number 4?
Plaintiffs?
No, as far as 6, what's the number as far as the doctor and the pathologist? Number of slides or?
Oh, there's 4 patients with 6 slides in the Burke article. And then I think there's 5 patients that we have slides for, including Mr. Yu and Mr. Ryerson. So it's slides from, I don't know what that leads us to, 9 different people.
So if I may inquire, Your Honor, is the court leaning towards allowing the slides in but not additional testimony as to the injuries of these other people? I just want to make sure whatever record we make is clear.
Well, I come back to, and I was wondering, and I'm looking at through this lens, it appears to me that what's being proffered would be
Just the
pathology,
slides.
pathology evidence as to what resultant hydrogen exposure looks like in the liver.
Correct, Your Honor.
Something like that, right? And that was, yeah, that's how I took it.
And real water is not contesting that in terms of
Well, true,
the
Your Honor.
slides for
There's
Mr.
3 other
Ryerson.
defendants here, so unless he's saying all 4 defendants are contesting it, you know.
All right. Yeah. And what I'm gonna do, as far as, I mean, I understand what it's coming in for, and I'm gonna permit it to come in for that purpose. Mr. Neale.
Thank you, Your Honor. And Your Honor, I don't intend to tell the jury that Mr. Morrison almost died.
No, we're not going to, this is
With regards to whether or not he was a liver transplant, I don't really see the harm in that. We had a death case as one of the 7 plaintiffs. I mean, well, that is worse than having a liver transplant. You actually die. So I don't really see this big prejudice that Mr. Odou thinks he sees, but.
That is prejudicial, and I guess we'll take that up if it comes up.
So we'll take it. But I think it really, I mean, in light of, you know, Nevada law, and I go back to the policy articulated in the Coca-Cola case, Andrew versus Harley Davidson, Kraus, and similar events, and similar event analysis, some of that. So I guess the motion's denied.
Your Honor, if I could, just very briefly, I understand the court's ruling and certainly I'm not trying to ask you to revisit it. I just want to make sure that none of these plaintiffs in either the Burke report or the Datnow slide report are, well, let me put it this way. Haley and Belsky, the two plaintiffs suing UNFW, are not among any of these patients. We don't know what some of the subsequent patients who are plaintiffs may or may not say. Mr. Hunwartson is suing UNFW, and we haven't had expert disclosures there. I just don't want our silence on this issue, although we joined in Mr. Odou's motion, to be misconstrued as
Acquiescence.
or without any objections we might later have to causation or the like.
For the record, you can set forth, you have a standing
Thank
objection
you.
as far as causation is concerned.
Thank
What was the other one?
Well, and even more pointedly, Your Honor, it's the plaintiffs who haven't yet been deposed, whose slides are in these studies, and whose expert disclosures have not yet been made, whose slides are in these studies. So we don't know yet whether we'll have causation questions or concerns there, but we certainly don't want to forfeit that right.
I understand. It's not right. So where do we go next?
Your Honor, the plaintiff will prepare the order on that last one, just
Yes.
housekeeping. And then I believe the rest of the real water motions eliminate are moved.
So why don't we go through them?
Let's go through and make sure, because
So motion eliminating number 11.
Tori will be
Sorry.
asking me questions at lunchtime. and We can answer those questions.
I think it's 11, right? 11's, he's ruled on.
Yes.
Yeah, and 11, I think the court's ruled on. That's
Okay,
okay.
so that's from that too.
Your Honor, motion eliminating number 11 was to limit the lay testimony of Vesitel and Congress. I believe the court in one of the UNFW motions denied a similar motion, and so this motion would also be denied as for the same reasons.
Do we know which motion? Okay, we'll just put down this one.
And then motion number 12, the court has ruled on both 12 and 13. We broke customer complaints out from complaints that predate the complaint, which is 12, and post-date the complaint, which is 13. And the court has already ruled those other complaints, or those other issues, I guess for lack of a better word, can come in. So those motions will be denied. And then motion eliminating number 14 is on immigration status, and this court's issued a minute order on that. So that motion will be granted. So that's it.
That's it.
Yeah, Judge, and where we go from here, we agreed with Mr. Robbins that we would not do the motion for summary judgment number 1 today. And football and then Milwaukee motion number 1, I think we also agreed not to do that today. I think we agreed not to do any of the Milwaukee today. So that takes us to claims motion eliminating number 22, which Mr. Parker is ready to argue. And then after that would be 23. Yeah, 23. Well, I got 24 being moved.
Okay.
Yeah,
Then we're off the page.
Yeah, I mean, we're going a little fast here. Okay. So why don't we try to get 20, you want to try to do 22 for lunch?
We can it's up to the court. 22 is good. I'm afraid
22
that
might be a little long.
it'll take a little bit of time. We won't finish it before lunch, but I'm afraid we'll have to talk about what comes after that because Ms. Anderson has a couple.
Oh, okay, so, does anyone not do 23 today?
I don't think we'll be able to, 23 or
All
25.
right, 25 too?
Yes.
Let's skip to 26 then. Can we do 26?
We can try to do 26 and 27.
27, I have, I know that we're gonna meet and confer, but on the 86 jury instructions.
We haven't done that yet.
Okay, and so we can try to do 26, and can we do 28?
I'm here today.
Okay, so we do 28. So we will,
29, I think, is already been decided.
we're gonna be closer to the addendum, I thought.
I think that's all right.
So we're gonna do, just next, let's try the next part. We're gonna do 28 I'm gonna do, right? 23, we're gonna wait till Monday, or we're gonna,
23 and 25 will be prepared to take up Monday if the
Okay.
court. Yes.
24, we'll motion made, 24 is, we're working this day. 26 we can do today, right? 27 we have to confer on. 28 we can do today. 29 is already resolved, right?
Yeah, I think that's the one the judge denied.
Tonight,
I don't have that.
I think it was part of UNFI's motion number,
this motion, number 29, to permit the consent decree should be denied.
I think that was part of UNFI's motion
yeah.
to prevent it, and I think the court.
Okay. And then our motion to permit Mr. George's video, that hasn't been heard. We can do that today, right?
Yeah, that'd be very quick.
And that's number 30.
That's,
30.
yeah,
Yes.
30. And then there's no opposition to 31 or 32, right?
That's what I have.
That's what I should say.
Okay, so those should be granted. And then we,
31, 32 should be granted.
31, 32. And then we have 33. Okay, that's yours, Judy.
And 33 and 34, I'm sorry, we'll have to put off till Monday.
Is 34 still an issue?
Yeah.
There's a
Okay.
minor,
Oh, you
we're not
still-
saying the cause of liver failure.
Okay. But how can you have the ER guy testify that? If you're not saying that dating doesn't cause liver failure, why do you want the emergency?
What's the record with
I don't think we do, well,
That's the only thing left. Why don't you take a look at that?
it's, okay, well, let's talk about it.
Okay, and then 35, 35, we had agreed to submit on briefs, 36 on the briefs, 37 is Goldsmith, I guess we can do that if we get that far. 38. What is 38? Where did my, oh, okay, the history, okay. Can we do that one? Can we do that one?
We can try to get to that one as well.
Okay, I think that's enough, I don't think we're gonna get quite that far, if we've sketched out enough. That's 11:48.
What's on the video now?
I'm
Hmm?
gonna take off.
Who is the video?
Someone deserves
See,
You guys want a breakdown, come back at 1:15, or we'll try to do
doesn't matter to me, we can argue now, or you want, what's the court preference, Sean?
I was looking, and
So what's the next one up in your opinion, Will?
22, this is what we'll do. How about this, it's 11:49, we will break and come back at 1.
Okay, thank you.
Thanks.
All rise. All rise. Department 16 is now in session on the 2nd. Presiding. Please be seated.
And let's go ahead and set forth our appearances.
Will Kemp, Eric Pepperman, and Theodore Parker. Joel Odou on behalf of the water defendants.
Scott Rasmussen on behalf of Hannah Instruments.
Afternoon, Your Honor, Jim Neale and David Spurlock on behalf of UNFW.
Afternoon, Your Honor. Jim Davenant for Will Water Tennessee LLC.
Reference for Milwaukee Instruments.
All right, does that cover all appearances? So next up,
Your Honor, it's motion in limine number 22, plaintiff motion.
Jason.
I'm sure you've read this motion, and I'm sure you've seen this motion in other cases as well. It's simply our attempt to prevent a lay witness from offering what I would consider, and I think based on our motion, we would consider expert testimony. Causation opinions that were solicited during his deposition, which we've identified in our motion, Your Honor. Chris, if you could turn to page 2 of our motion.
I mean, you see that more often, like in medical malpractice cases.
Absolutely, Your Honor. Absolutely. That's a great example. You know, our firm represents UNC, and quite often we're having to file these motions. So I understand a plaintiff's attorney trying to guard against such. But in this case, deposition questions were asked of Mr. Brent Jones, trying to get him to, of course, for purposes of UNFW, for example, to base causation on the Henderson location versus the Desert Inn location, or to base it on perhaps home delivery operations as opposed to hydrazine being in the water or in the concentrate. And so we'll just use an example here. Page 3, go to page 3 for a second. Thanks, Chris. Lines 13 through 18, Your Honor. These are questions presented to Mr. Jones, where he says at line 16 and 17, he's answering affirmatively that he believes that the product from our Real Water Las Vegas home delivery operations has caused this health issue. You go, and again, these are very leading questions. But if you go right below that, the question is asked, the root cause is the 5-gallon home delivery product. You see that, and then right after that, he's asked to agree, and he says correct. Now this is not, if you look at NRS 50.265, these are not observations made by Mr. Jones. This is information he's gathered through leading questions. He's led to indicate that through deductive reasoning, he's come up with this being a home delivery issue or a Henderson issue. He was not given the information from the MMWR report, for example, nor should he. He's not an epidemiologist to provide causation issues. The defendants, UNFW, did not retain an epidemiologist, so they're trying to get what I would consider to be epidemiology type opinions through opposing Mr. Brent Jones here, and then presumably perhaps having him do it in front of the jury. And that's not allowed, Your Honor, and it's certainly not supported by NRS 50.265. Your Honor, I think the court is so familiar with this type of motion that I don't believe that much time needs to be spent, but if the court has any questions about it, we gave further examples by way of our motion on page 4, Your Honor. And I direct the court's attention to page 4, lines 9 through 16. And he's being asked questions about the result of the investigation of the Southern Nevada Health District and the FDA, and again, linking it to the 5-gallon home office delivery. And you can see his response again, yes, on line 14. So he's being directed to answer the court in a very leading format to give causation opinions which he's not equipped to offer. He doesn't have the foundation to offer them. And again, he should not be allowed as a lay witness to be able to give causation opinions. Any questions, John?
Not at this time.
Thank you.
Okay, let's hear from the opposition.
Thank you, Your Honor. Jim Neale on behalf of UNFW, and I hope the court understands that not every question that's asked at a deposition is asked because the same question tends to be asked at trial. So I assure the court that
I know the difference between discovery and trial.
I have no doubt that you do.
Yes, and also the trial depositions and discovery depositions.
Yes, sir. And I have no doubt that the court is more than capable of enforcing 50.265 at trial. And I'm not going to walk close enough to that cliff that the court's tempted to push me off, and I'm not going to give Mr. Parker the opportunity to, if I can help it. But I would like to go through some of the materials, Your Honor, and explain what I think is well on the safe side of 50.265, and what has to happen here, because I don't want the court to grant this motion and anybody to misconstrue the scope of it or the breadth of it. Let me first correct the factual record. Dr. David Atchison is an epidemiologist, and he is a retained and disclosed and deposed expert of UNFI. Where the notion comes from that we don't have an epidemiologist is beyond me. And I say that mostly because we don't need lay people to give epidemiological opinions. What we do want lay people to do, Your Honor, is to provide the factual basis for the distinction between an outbreak that you've heard others refer to as the super bad batch in 2020, that public health authorities recognized and defined and very specifically related to the 5-gallon product, versus what the plaintiffs allege in other regards. So, Your Honor, just very briefly, and I think these facts are becoming more and more familiar to the court, something happened in the fall of 2020, something that was different than everything else that had ever happened in the history of Real Water. It was right around the time of Real Water's move of the 5-gallon manufacturing line from the Desert Inn facility to the Henderson facility. And you've heard Mr. Kemp and me spar about exactly when that occurred, or Mr. Hoffman spar about exactly when that occurred. But what we know with absolute certainty is this, that in the fall of 2020, Real Water received about 25 to 30 consumer complaints, complaining that the water had an off taste or off smell or was making people sick. Now, the court's already ruled that those are admissible. And those are not the complaints you've seen. Those are complaints that were made over the telephone and other means to Real Water in Henderson in the fall of 2020. Every single one of them, Your Honor, was from a 5-gallon customer in the home and office delivery area. That's the testimony of Anthony Brown. Every single one of those complaining consumers, Mr. Brown determined, drank water that came from the single 5-gallon fill machine in Henderson. And John, if we could just pull up, well, don't worry about that. And that, Your Honor, was around October of 2020. October, November. It's the same time those 5 children were airlifted to Utah and treated for severe liver injury. Those 5 children, not coincidentally, Your Honor, were also members of families that were 5-gallon subscribers. All right, so Mr. Brown, Mr. Jones, Mr. Woelfel, all of the Real Water employees whose phones were ringing off the hook with complaints from customers around that time got exactly 0 complaints from retail customers of the same problem. None at all. And that water, Your Honor, at that time was made on different machines by different employees in different places in a completely different facility. That obviously affected the way they attempted to identify and isolate and correct whatever the problem was. So they did what's called the root cause analysis, and they traced back the products that these complaining consumers had to see if they couldn't identify what went wrong. And Mr. Brown, who's the director of the home and office delivery for Real Water at the time, personally fielded these complaints. He personally determined, this is page 233 of his depositions, Exhibit H, Your Honor, of our opposition. He personally determined that each and every one was a 5-gallon customer. He personally determined that there were no comparable retail customer complaints at the same time. He personally confirmed Real Water's delivery records and showed that all of the complaining customers took delivery of the water around a particular time in mid-August, or mid-October, as I recall. And then he worked backwards using his knowledge of Real Water's production habits to determine that the water was made approximately at the time he was on an extended weekend birthday vacation away from the facility, and the new lead technician, Mr. Casey Aiken, was working alone. And at the same time, Your Honor, he determined that Mr. Aiken was, number one, complaining of a faulty mixing pump, and number two, calling Mr. Jones about his test results and being told to put more concentrate in the water. Right. Everything I just mentioned, Your Honor, is a fact. None of that is an opinion. And I would suggest to the court that all of the testimony that we're going to elicit at trial that I just went through is recipient factual witness testimony that doesn't run afoul of 50.265 or any other standard of evidence. So I'll stop there and just hope that the court agrees with me and see if it has questions about the basic pattern there.
None at this time.
Okay.
I have thoughts.
Okay.
But, and I'll get to that, but I'll have that for Mr. Parker and both of you at the same time.
Yes, sir.
Yeah. But no, go ahead. Is there anything else?
Well, so then what happens, Your Honor, is this, and these are more facts, I believe. The children are in the hospital. Dr. Guthrie notices this aberration. He calls it to the attention of the public health authorities. And they do their case-finding efforts. And Your Honor, you'll recall, John, if you could pull up the MMWR, they later report on those. And they note that the retail product is distributed nationwide and that the case-finding efforts were therefore not geographically limited. And they report, nonetheless, Your Honor, that all of the probable cases they were able to identify were home and office delivery customers, just like those 5 children. And all were in the home and office delivery area. And none were exclusively retail consumers. Right? So again, those are facts, and the jury can do with them what they want. They may consider those facts compelling, they may consider them unimpressive. But there's no reason that those facts cannot be relayed to the jury. And there's no reason that I can't ask witnesses at Real Water or otherwise, are you aware of facts that are different than that? Or are you aware of any facts that call that into question? Or are you aware of something they weren't aware of? And when we did that in discovery, the answers, of course, were uniformly no. So what that takes us to, Your Honor, is the government conclusions. And you've seen a number of government conclusions already. You've ruled that those are admissible under 51.155 in the form of an EIR, for example, of the Henderson facility. John, if you could pull up Exhibit I, please, the Utah letter. This is the Utah, and it's on the screen for you, Your Honor. This is Exhibit I to our opposition. This is the state of Utah's consumer advisory regarding their investigation. And John, can you blow that up for us, please? And scroll down. They announced the recall. They warned consumers not to drink the product. And then the paragraph there beginning, the recall is the result. Your Honor, the government agency, in this case, the Utah Department of Agriculture, in issuing a consumer advisory says, the recall is the result of an investigation by the Southern Nevada Health District and the FDA after reported cases of non-viral hepatitis in or about November of 2020 were suspected to be potentially linked to Real Water's 5-gallon home and office delivery. They're just matter-of-factly reporting. It is a record, report, statement, or data compilation in any form of a public official or agency detailing the activities of the agency, the matters observed pursuant to a duty imposed by law, and factual findings resulting from an investigation. Just as the plaintiff's EIR is admissible, the MMWR is admissible, so too is the Utah Consumer Advisory. Similarly, Your Honor, Mr. Jones' apology video that he posted at the time, where he reported the findings of Mr. Brown and said, "We're very sorry," there are words to this effect, "We're very sorry, there does seem to be health problems associated with our 5-gallon home and office delivery product," is admissible. That is under 51.035, not hearsay, because it's made, Your Honor, it is a statement offered against a party that is the party's own statement, either in his individual or representative capacity, it is authorized by the party. He's the president of the company. And it is concerning a matter within the scope of the party's agency or employment. And it is utterly, again, it's inconsistent with his pecuniary interest. He's inviting liability by saying that. It has all the indicia of reliability, therefore it's not hearsay under the statute. So, Your Honor, for that reason, the specific examples of the Utah advisory and the Brett Jones apology are admissible. And as I hope I've perhaps convinced the court, the other factual basis, the absence of complaints from retail customers, coupled with the sudden and numerous complaints made by the 5-gallon customers, are facts that are admissible that underlie the epidemiological conclusions of numerous public health agencies and experts in this case. The last thing I'll add is this, Your Honor, both Wilson versus Circus in the foodborne illness context and Galloway versus McDonald's in I think a premises context make clear that the absence of injuries is admissible. And the last thing I'll suggest to the court is this. You have, in your minute order, established I think it's a 6-factor test governing the admissibility.
And there's no doubt, and I don't mind telling you what I was thinking about when I was reading this. There's a difference between potentially facts and opinions.
Yes, sir.
And what I mean by that is this. I'm looking here and I was thinking about this, page 5, and Mr. Parker can address this. I see a difference between Brown and other Real Water principles made a root cause conclusion versus conducting an investigation. What did you find?
I agree, Your Honor, and let me try to put the court's mind at ease.
You see what I mean? No,
Absolutely.
Yeah.
So Mr. Brown does all the factual legwork, and he comes to an obvious conclusion. And that may be fine, and that may be important, and we may encourage that in the manufacturing setting. We may at the same time prohibit him from giving the conclusion to the jury. But that's the same conclusion that the public health agencies came to. That's the same conclusion that the retained experts came to. We can elicit his facts. His conclusion may or may not be independently admissible, but certainly the experts in the public health agencies can make their own admissible conclusions based on that. That's what we've got here, Your Honor. And that's why the court should deny the motion and allow the factual testimony, or at least deny it without prejudice to be made at trial, renewed at trial when a specific objection comes up. Thank you, Your Honor.
Bring up the reply, Chris.
Your Honor, the more I listened to Mr. Neale argue the opposition, the more I thought he was agreeing to the motion. And it's because in our motion, and this is something, you know, I learned a long time ago, and I think we made it clear in other cases I've been involved in. If you're gonna do a motion in limine, actually tell the court what you're trying to preclude or what you're trying to get admitted.
Right.
We, in this motion, and I applaud Mr. Kemp's office, said specifically what we're trying to prevent from being solicited during examination of a witness. Having a lay witness give causation opinion for which this lay witness has no foundation, no credentials, no experience to provide. This is not just something that Mr. Brown, Mr. Jones observed. This is a causation, root cause testimony that they were seeking during deposition. And certainly we all understand the difference between discovery and admissibility at trial. Your Honor, we pointed out in this motion exactly the type of causation opinions that lay witnesses shouldn't offer, and shouldn't be asked to offer. And instead, Mr. Neale turns this into us asking the court to prevent a witness from talking about facts that that witness ignored or would have available to.
Well, that's why when I looked at it, I was kind of focused on the root cause opinion.
Right.
And I don't know what, I mean, I understand the term root cause, but from a legal perspective, we don't use that term of art, right? We use proximate cause or whatever. But, and I see, and my point is this, and this is what I thought about, and there's no question counsel was right as far as the parameters I set forth, as far as facts are concerned, right? And that's different than conclusions. That's why I asked that question. Because I pretty much opened up the door as far as facts are concerned, haven't I?
Absolutely, Your Honor. And that's why I thought Mr. Neale's opposition or his argument was, I guess, agreeing with our motion.
Well, I
We're
don't know if
trying
it was
to
agreeing
seek
or not.
clarification on facts.
But tell me this, why would, I understand coming to the conclusion as to what a root cause analysis is, right? But as far as, well, when you conducted your investigation, how many complaints did you get from these individuals, those individuals? So that's facts.
Yes, sir.
That's right.
Right? And so, think about it, you know, it's a much different case than you traditionally see in typical personal injury. It's a hybrid mass tort with a little bit of products liability and so on and so on. And Nevada courts have been pretty clear as far as what they let in. And for example, we're letting in consumer complaints. This makes sense to me. We would let in where those complaints coming from potentially too.
Or the absence of complaints at other times.
Well, that's a good argument. I mean, you bring that up.
That's
I
the
mean,
goose gander rule. It's a universal
well, I don't know
truth.
if I believe in a goose gander, but I think it makes perfect sense regarding if it's coming in,
Yes, sir.
right? You know, and I'll tell you why I don't believe in a goose gander rule. I'll tell you that.
Okay.
Because it's real simple. Each decision is just based upon what's in front of the judge, right? So you don't say what's good as a goose, what is good for the gander. You say what I'm saying right now, facts
It's the same.
versus conclusion, right? Right? That's a different
That's
issue.
difference. Thank you.
Yeah. So I'll make it real simple. I'm gonna let the facts in and just not the conclusions.
Thank you, Your Honor.
That's all. The facts are coming in, right? That's part of it. And the jury can draw whatever conclusion they should draw based upon a creative argument of counsel.
So, Your Honor,
Yeah.
I think that brings it to conclusion from the discussion. I wanted to make sure that, just for record, looking at the opposition, there's nothing in the opposition, the paperwork that is, not the argument made by Mr. Neale, that actually disputes the causation testimony that was identified in the motion. And in part, the opposition talks about the investigation, which again, factual information, wasn't a part of our motion. So I think strictly looking at our motion the way it was fashioned, fashion, Your Honor, and again, the way it was discussed in the reply brief, I believe that the court would be consistent with the other Nevada Supreme Court cases we cited, the Crawley versus State, which is a 2011 Nevada case, the Burnside versus State, which is a 2015 Nevada case, and the Jesdick versus State, which is another 2005 Nevada case. The only other case we cited was a Ninth Circuit case, and they all support lay witnesses not being able to give testimony, expert opinions, Your Honor. Two of the four Two of the cases, as the court recognized when I first stood up, dealt with medical malpractice cases, Your Honor. The latter two dealt with the cell site tower where a layperson was trying to give an opinion regarding coverage for cell site operations. And then the Jesdick dealt with handwriting analysis by a layperson, a private investigator trying to give a handwriting opinion. So in terms of those causation opinions or expert opinions, Your Honor, we ask that the motion be granted. In terms of the apology document, Your Honor, and which was the Utah, I believe, in relationship to the Utah agency report. Again, I don't know how Mr. Neale intends to introduce that. That was not a part of our motion. I think that he's trying to expand our motion in an attempt to ask the court, his own motion in limine, I guess, a counter motion in limine, to bring that document in. I think it's inappropriate for the court to make a decision on that document at this time. And I'm assuming he was bringing it up for an example, but there is no motion in limine that I'm aware of that they filed on that document.
Your Honor, it's page 4 of their motion in limine. They specifically say that document and the deposition testimony about it. And that's why we included it in our response, and that's why it's admissible.
To clarify, Your Honor, the Utah letter is a letter written by the Utah health authorities relatively early on in this, before anyone had done any sort of investigation. And that letter refers to a so-called conclusion by the Southern Nevada Health District. So it's the Utah people saying something that they attribute to the Southern Nevada Health District. And we know for a fact that Southern Nevada Health District hadn't even, they were in the middle of their investigation at that point. So to argue that this is some sort of health conclusion by anyone, I think is inappropriate, that the Utah letter should be out entirely. And again, we haven't deposed anyone. The author of the Utah letter hasn't been deposed. No epidemiologist from the Department of State of Utah has been deposed. And we have deposed the Southern Nevada Health District people who make it pretty clear that if their investigation hasn't even finished as of today. The apology video, which was also addressed in the pleadings, that's where Brent Jones, the owner, not Blaine Jones, Brent Jones, gets up and he says, hey, this is just a problem with the 5-gallon jugs. And again, this is very early on, Your Honor. I think this is either March or April, or might even be February, but it's very early on. So, I mean, no one even had heard of hydrazine at this point. No one knew the scope of the injuries. So to suggest that we should have a lay epidemiology opinion, which is what this is, that the problem is limited to the 5-gallon jugs, that's not a factual observation, that's an opinion. And so that should be entirely out. So the Utah letter and the apology video should be out. Facts, we don't have any problem with the opinions Mr. Parker's already talked about.
All right. Let me make sure we're clear. I thought that the comments you made to Mr. Neale regarding facts versus conclusions would necessarily mean that Mr. Jones could not come in and give an opinion as to a determination potentially made by a Utah agency, because then that would go back to a causation opinion.
I don't mind saying this.
Yeah, I don't.
And we talk about what's good for the goose is good for the gander. Also, what's good for the, fair to the trial judge. And I don't mind saying this, when I looked at this at the very beginning, I looked at it from a traditional lay people can't give causation opinions, right? And so that's why I asked the question on root cause, right? And that's not necessarily a basis for any causation opinion under Nevada law. And then I circle back, and as far as what Real Water did in their investigation, at the very beginning, that's facts. And that's why I said facts versus conclusion, right? Because I've lived in other facts, right? And so, and here's a difference too, and this is, the facts are the facts as far as where the complaints came from. I'm gonna let that in, right? I mean, that's coming in. But as far as ultimate conclusions, as far as causation, we got experts for all that, right?
And
That's the plaintiff side and from the defense side. But what I'm trying to do is I'm gonna let the facts in. Well, what did you find early on? I mean, I don't know what he's gonna testify to, but let's hear what they did. But when it comes to ultimate conclusions, and then this is kind of how I look at it. I'll be really clear. I'm gonna grant the motion. However, that's limited to, what's the term of right they use, that root cause or causation type opinion, right?
Root cause investigation.
Yeah, root cause, yeah, that,
The
right?
conclusions.
The conclusions, right?
Yes, sir.
Yeah, but as far as, okay, where'd you get complaints from? That's gonna come in.
Absolutely.
You see where I'm going on that?
I do.
And then as far as any, and I'll be, and here's one point that's really important to point out. If you wanna do a separate motion on the Utah, whatever, this is to deal with that separately, because I don't mind telling you this, when I was reviewing it, I wasn't looking at it from the letter perspective. I was looking at it from the causation opinions, net cause and so on. And I agree with you. I agree with, I mean, as far as the investigation and where your complaints came from.
Your Honor, that's a great way for us to start the weekend. I think we should.
I think we should go home
On
now.
that moment, we should all skip off into the sunset.
Well, that would be nice if I knew there was a settlement.
I've been waiting weeks to hear you say that you agree with me.
Yeah.
It's wonderful.
Wait a second, he's denied a few of my motions based on your opposition.
Thank you,
He's
Your Honor.
agreed to you a few times.
I think we understand the court's rule.
Yeah, but that's, you see the distinction? It's
Absolutely.
Yeah.
Absolutely.
Your Honor, just for the benefit of Mr. Kemp over here, I think I heard something about something. Your Honor,
I just wanna make sure the opinions are out. So
Yeah,
the Utah opinion's out, and
Opinion, right.
Mr. Jones's
Well,
opinion.
here's the thing, and let me be real clear. If there's, what did I say regarding the Utah stuff?
File a motion if you want to file.
That's what I said.
We're here. We hear you loud and
We
clear.
addressed that in this motion, Your Honor.
so,
where was
that's,
that?
this is what I think the breakdown is, Mr. Kemp. This is one of the few times that me, Mr. Neale, and the judge are on the same page, so,
I'm sorry.
yeah, this is something weird happening right now. But, this is what I believe the difference to be, and someone can correct me if I'm wrong. The Utah document, it is what it is. The opinions within the Utah document that are from Mr. Jones, if it's an opinion, it's out. If there's a fact, I did an investigation on day June 1st, 2012, and I found this, that's a fact. But his opinion, a causation opinion, a conclusion, based upon something he read from someone else or gathered from someone else would be out. That's my opinion of what the court has said. Is that?
Do I
You
have,
understand?
do I have,
Judge, if we can have the Utah letter back up. The Utah letter
I'm
is,
trying to think, do I even, I'm looking.
You do, Your Honor. It's exhibit I to the opposition.
Okay.
in the Utah letter, and I don't remember the date, but it's very early on, okay? The Utah letter is just, it's April 1st, 2021, okay? That's before we have really any type of investigation. We have a preliminary investigation by everybody. So the Utah letter, go to the bottom, please. This is the problem. They say that it's, the recall is a result of investigation by the Southern Valley Health District and the FDA after reported cases, and they're linked to the 5-gallon home delivery. That's not a fact, Your Honor. That is a statement that the Utah people are making and attributed it to, it's potentially linked, okay? I mean, this is an opinion, and so what they're gonna do is they're gonna introduce this letter and they're gonna say, look, the Utah people agree with us. But it's not even a Utah opinion, it's a statement of the Southern Valley Health District, and we've already taken the deposition ad nauseum of Dr., what's her name? John. I mean, and we expect her to be a live witness here. She can tell us what they found and what they didn't find. But to to suggest that we should go back to a
What's the
letter
bait stat?
Go,
of this letter.
9648, Your Honor.
9468. You said 96, it's 94.
9468, thank you.
So that's the Utah letter. The Jones apology is even worse, because that's his conclusion, and Mr. Neal says, oh, that's admission against interest. Well, he's not the plaintiff in this case, Your Honor, I'm the plaintiff, okay? So you can't have one co-defendant admit irrelevant evidence against another co-defendant and say, oh, it's admission against interest. So that just doesn't work, but this is a statement by the president of the company, who's, I don't know if it's in good faith or whether he's thinking outside the box and trying to limit his liability at this point, just limit it to the 5 gallons. I don't know. But it's an opinion by the president of the company who really has done no investigation whatsoever. And even if he did, he's not an epidemiologist. So to allow him to state his opinion or his son to state their opinions, that should be out, Your Honor. That's not a fact. That is an opinion. And this is a repeat of an opinion. So both of these things are covered by the motion, and both of them should be out.
So, Your Honor, I don't think that either of these were covered by the motion. I thought I heard the court invite a specific motion eliminated to exclude these. If we're gonna argue it, I'd like to say a few things.
But not only are they attached to the opposition, but they're covered in the reply.
On the Utah letter, I'd like to say this. This is weeks after the EIR that you've already admitted from Southern Nevada Health that has facts, conclusions, interviews, double layers of hearsay, et cetera, et cetera. Everything that was true of that document is true here. The analysis ought to be strictly the 51.155 analysis, the public records.
I don't know if I
You're
see
still
it.
looking for it, Your Honor?
I don't even have it attached, I don't think.
It should be Exhibit I, Your Honor, to our opposition.
So
And
that's,
that's motion eliminate number 22.
No, I'm in the right motion,
Okay.
it is. Let me see it.
that's,
He had 22.
yeah, right. I don't have the exhibit attached, I got it. No, I got the motion in the opposition.
So if we're gonna argue that, Your Honor, the argument would be that it's absolutely no different than the other governmental documents you've already deemed admissible under 51.155. It sets forth the conclusions of the agency and the investigation that they, by law, are obligated to do.
These are not the.
Wait, I wanna make sure you get this all out.
On the apology video.
Thank you.
Thank you. And again, Your Honor, I'll remind the court of what you, I think, correctly told us very early on in these hearings when we were arguing these motions. You explained certain hearsay documents that would otherwise be hearsay are admissible because they bear indicia of reliability. And the legislature has categorically declared them to be exceptions to that rule. And certainly the public records exception is one of those.
And I just want to make sure, are we talking about the consumer advisory?
Yes, sir.
One page?
One page. This is the State Department of Agriculture for one of the 4 states that most thoroughly investigated the incident, that had concentrate coming to it, that had the bottling facility in Mesa near it, that had part of the home and office delivery area, that did the case finding efforts, and that was working hand in glove with CDC and FDA and Southern Nevada Health. And what they say, I think, very clearly is not so much a conclusion of the investigation, they simply report the correlation, the same correlation that Anthony Brown did. And they note in that paragraph, Your Honor, that the
Which,
recall,
in which paragraph are we doing?
this is the last full paragraph, Your Honor, the recall is the result. The recall is the result of an investigation by the Southern Nevada Health District and the FDA after reported cases of non-viral hepatitis in or about November of 2020 were suspected to be potentially linked to Real Water's 5-gallon home and office delivery. They are saying the same thing that the CDC says in the MMWR, which is all of the probable cases were 5-gallon customers. They are saying the same thing that Anthony Brown did in reporting his factual investigation, which is to say that all 25 to 30 of the complaints that I received were 5-gallon customers. That's not a causation opinion, that's a factual correlation that they're accurately reporting. Even if it were a conclusion, Your Honor, it'd be admissible under the public records exception.
Chris, can you put up our reply brief, page 5, please, so that we can address this further? All right, Your Honor, you have our reply brief where we address this issue. Truly, in my listening to Mr. Neale's oral opposition, I thought we were limiting the document to the actual information that could come from Mr. Jones. But it's my belief now, given what he said, that he's intending to get this entire press release, attempt to get it into evidence at the time of trial. So let's look at the document as a whole. You know, no one has been, to my knowledge, identified or listed through a 16.1 disclosure to testify on this press release. And if someone has, that person hasn't, certainly has not been deposed. So I'm not sure who that person is, and who's gonna be able to come in and lay the foundation for this hearsay document. Now, Mr. Neale takes an opportunity to use a very convenient argument at the time, saying that the court has agreed to let all of these documents in under the business records exception to the hearsay rule. Well, that's not what the court has done. The court, instead of applying a shotgun approach, has applied a rifle approach based upon the motions we filed. What we did do, which the court has not denied, was our request to get the consent decree in. Because in our opinion, that consent decree, a business document, something they signed as a part of an investigation, a way of actually any further punishment or assessment being, fines or assessments being made, entered into that agreement. Mr. Neale has persuaded the court that the consent decree should not come in.
Well, actually, that was case law.
Well, that part, Your
I
Honor.
mean, he knew it's case law. I don't mind saying that. I understand I've looked at a lot of motions since then, and sometimes it's tough to keep up as to what exactly has been ruled upon. But I think my decision, I think there was some pretty good case law on point as far as consent decrees and admissibility, and there's settled, you know, that's kind of what I think I did.
We went back and forth on that. And certainly plaintiffs believe that that document was admissible. And Mr. Neale had just indicated that the apology was some way of Real Water's representative explaining and taking accountability, which is very similar to what that consent decree does. It's explaining and taking accountability as a part of the conclusion of an investigation conducted by the Southern Nevada Health District. Now, the document, the press release, talks about something that may be probable or possible or suspected, but there's no foundation for the opinion included in that document. And so now Mr. Neale would like to have a owner of Real Water come in and regurgitate his belief based upon an incomplete investigation through the Southern Nevada Health District, then purported by a press release coming out of Utah. I don't know how many layers of hearsay that is, but it's a lot. And certainly that document shouldn't be allowed to come in. And that's what Mr. Kemp was alluding to earlier. And so we did address it in our reply brief, Your Honor. And it's our position that that document should not be allowed to come in because it is hearsay, because it's not a properly founded opinion. It is a layperson trying to render an opinion that an epidemiologist would provide. And there, Mr. Neale is, of course, trying to use it to shield UNFW. And that's what's happening here. There's no exception to this document coming in. This is not a business record of real water. I don't know what party he's speaking of that this would be a business record of. It's a hearsay document, plain and simple, and this hearsay document includes an unsubstantiated, unfounded opinion of a layperson. And that's why it's a part of this motion, Your Honor.
Do we even know who the author is of this?
No, Your Honor.
We do not. That's why I said I don't believe anyone has been identified in the 16.1 disclosures, Your Honor, who would be able to give that testimony. So when I said addressing the document by itself as a part of the latter part of our discussion, Your Honor, it was because I was not aware of anyone who could bring this document in, lay a proper foundation for it to have it come in at the time of trial. But I also knew that in and of itself, it's a hearsay document including opinion from a layperson who does not have the ability to give and offer such opinions.
Here's my next question. As far as the reports and conclusions of the Southern Nevada Health District, were they deposed?
They were deposed, Your Honor.
Southern Nevada was,
Southern.
yes.
Southern Nevada was. And
Yes.
we're not arguing about the Southern Nevada Health District people. We deposed the primary physician, Dr. John, I think Jonghe.
Zhang.
Thank you, John. I'm getting her mixed up with Dr. Dijon.
With the dinner you owe me for the Dutchman.
I owe you one bit. That's true. I'll take care of it.
Your Honor, I'll just remind the court, Mr. Pepperman very capably argued when he was moving for the admission of the EIRs and the other FDA and CDC documents. Of course, we have not deposed these people. They won't be deposed. They're public health agencies. That's why the documents come in on their own, and it's exactly the same thing here. I don't want to get hung up on the.
No, I'm not. I'm just looking at this.
It's a press release. This is not an FDA, CDC, Southern Nevada document.
We can stop arguing now. Can somebody just make me copies of the other documents so I can just look at them?
Sure.
I just want to, and you don't have to do it right now, just before the end of the day.
When you say the other document, Your Honor, you mean the apology?
There's an
No,
apology video.
not the apology. I'm looking at the,
You look at the
EIR.
other agency
Yes.
documents. I got it. Compare it to the press release.
yes.
Understood, John.
What do you want us to do with the apology video? I think there's a transcript of that.
We can play it if the court would
But
like
I
to see
mean,
it.
but here's the thing about the apology video, and I think I've been pretty good as a fine line here. I don't have it in front of me, but does he say what the cause is? What does he do?
Judge, I think the best thing would be just to play like Mr. Neale suggests.
Okay, if both, you don't agree on much, I'll listen to you.
This is Mr. Brett Jones, Your Honor, the president of AffinityLifestyles.com and Real Water Inc. I believe, Joel, is that correct?
Hello. We feel it is important to issue a personal statement regarding the recent FDA investigation associated with Real Water. First, we'd like to express our deepest sympathy and concern over the events that led to the inquiry. We started Real Water over 13 years ago with the intention to provide a healthy product that benefits and elevates people's lifestyles. We're deeply saddened to learn that anything otherwise could be the result. I often reach out to tell you about Real Water's commitment to quality. Your trust matters to me, and I'm proud of how far we've come. Therefore, this recall is deeply concerning because you should never have any worry about the safety of any of our products. I want to personally apologize to all of our customers, and I assure you that the lessons learned from this will drive further improvement in the brand. As the majority owner and founder of Real Water, I want you to know that I stand behind every product we sell and safety will always be our top priority. For the 13 years we've been making rural water, we've received an overwhelming amount of positive feedback from customers. Although it appears that all incidents are related to our Las Vegas home and office delivery, we have issued a voluntary nationwide recall of all rural water until the safety of our product is clearly established. In this regard, we have posted our latest water quality report from an independent third party on our website for your review. Also, we are cooperating with the FDA in their investigation. We'll issue additional press releases once we learn more. We're grateful for your ongoing support and will continue to do everything we can to meet and exceed your expectations. We value you and your continued trust in rural water. Thank you.
What does that have to do with anything in the case? That's my first question.
It's the statement he made that it appears likely that this is a 5-gallon problem. That's the statement they want in, Your Honor.
I think Mr. Kemp rephrased it to make it sound much more conclusive than it was. What Mr. Jones said was, although it appears that all incidents are related to the home and office delivery, we are recalling all products. And so all he's doing, Your Honor, is reiterating the same thing that Mr. Brown said, which is all of the complaints we're getting appear to be related to the home and office delivery product. That's the factual basis that we want to introduce to the jury. We think there, despite the common ingredient of the concentrate, despite the fact that hydrazine at trace levels was found in both, we think that there's something different going on with the 5-gallon product here that precipitates 2.5 dozen complaints from a bad batch while Anthony Brown is on vacation and Casey Aiken is minding the store alone. We think this is part of the factual underpinning of that, and that's why it's important that the jury hear these underlying facts. There's no conclusion there. There's no opinion there. All he's doing is saying, we're sorry, this is bad, we're going to try to do better, and even though the problem, the complaints, see all the incidents are related to the home and office delivery, we're recalling everything. There's something for everybody there.
Yeah, but my point is this, I don't think I've ever seen an apology video in any case admitted for the fact finder as evidence. That's my point, regardless of what he said or didn't say.
Well, I don't think there's a prohibition against apology videos. It's a statement, it's certainly a party admission.
Your Honor, it's an opinion throughout. I don't know where the facts came. What part of that was factual? I think there's a reason why Real Water did not join in this opposition.
Well, I think
This gentleman was giving an opinion based upon an ongoing investigation where he's trying to surmise what the results may be. That's nothing but opinion. If he'd come in here, like Your Honor said, and said, an investigation started on January 12th, and we believe it's going to be done on July 15th, and in between, we're going to recall our water. Those are facts. But when he says we suspect,
But here's the thing.
none of that, that's all opinion.
Why can't he potentially testify subject to cross-examination and objections and so on and so on? And my point is, I come back to, and apology videos coming in, right? I mean, I'm trying to figure out where
Let me tell you why it
from.
doesn't come in, why you don't see it coming in other cases, Your Honor. Typically, a lawyer has prepared the apology video, or some person working on behalf, a PR person. We've seen this all the time, and that's why they don't come in. Because they're not the thoughts.
I don't see it as a statement against interest. Yeah, there's an apology, but if it was a statement against interest, it said, yeah, we were negligent, we should have never produced the real water in the way we were manufacturing. Yeah, we failed to have
Hydrazine it.
we failed to
poison.
have QC and or QA and so on and so on. That might be an apology video. But I mean, I'm looking at it, I'm trying to figure out, and understand this, the underlying issue is this, when it comes to, hey, where'd your complaints come from? That's a fact.
That's right.
that's the fact. I think that's what Mr. Jones says. He says it appears all incidents are related to the home and office delivery. That's why we want the admission. All he's doing, Your Honor, is reiterating, saying again what Mr. Brown said.
That's an opinion and conclusion, Your Honor.
I get that, and we want to hear where he's coming from. right? We want to hear, what did he do?
Thank you. Everything else is an opinion, and I like what Mr. Neale said, it's a regurgitation of something else he heard. That's it. It's an opinion. I suspect it could possibly be related to this. That's nothing but opinion, Your Honor. It's unlike, we received information that 3 of the tests of the concentrate included hydrazine. Here are the test results.
I think what he's saying,
The conclusion would be, hydrazine got everybody sick. That would be a conclusion, correct? Not that I need you to say yes, Mr. Neal, I'm saying that rhetorically. But that's the difference between the.
No, I would say that, I think he's crossing this when we're supposed to be addressing the court.
Exactly, you're
No,
right.
listen, I'm
No,
directing
they're
to the court.
fine,
It's
though. They're
it's
not
food for
smart.
the
These guys
entire.
get along, I'm not saying anything.
Yeah, exactly.
Listen, I own dinner, what are you talking about?
That's on the record, too.
On the record.
several times.
But Your Honor, the point is, exactly what Mr. Neal is saying in terms of the apology, those are all opinions, and there are conclusions. He's saying this is what we believe to be the conclusion, the cause. There's a backdoor attempt to get a causation opinion in through a real water representative, not capable of providing you an opinion like this. These weren't factual remarks, Your Honor.
Your Honor, he does not say anything about the problem being limited to one machine. He doesn't say the problem is limited to one product. In fact, he says the opposite. He says we're recalling everything. He says it appears that all incidents are related to the 5-gallon home delivery jug, and the court's absolutely right. He can be cross-examined about the fact that hydrazine is present in both, that he recalled both, that potentially the problem spanned both.
Right, but I agree 100% with you, except for one exception. I think you should be cross-examined, either call it as a hostile witness and/or potentially cross-examined after defense does their case in chief and they put him on a stand as a witness. That's a different animal.
Oh,
And that is different than playing an apology
he will be
or
cross-examined.
sending that document.
He will be cross-examined, Your Honor. We've just subpoenaed him. He'll be here, I hope, or his deposition testimony will be used.
Which means you don't need the apology in the press release.
But we ought to be able to ask him, like we can ask anybody, you said that all incidents appear to you to be related to this product.
And you can do that, and hypothetically, if he doesn't respond, maybe you can show a portion of the video. What I'm not gonna do is, yeah.
I understand.
Yeah, I'm not gonna let the video in.
Thank you.
But I mean, the bottom line is, I do need to see the other stuff, the other.
The EIR, yes, sir.
The EIR stuff. I gotta
All right.
see.
Thank you, Your Honor.
Because this is a press release. But as far as, I'll be real clear, no root cause analysis, no causation. If there were complaints, where did they come from? Just like there were complaints about the water. Same thing, right?
Right. Thank
What's
you, Your
good
Honor.
for the goose is good for the gander.
Well, we've got him saying it now.
That's not why I did that.
So, Your Honor, motion-
We're gonna hold to that one.
No, it's not that, it's because of the.
I agree,
Yeah.
I agree, I'm just saying it with you.
We can enjoy ourselves.
Absolutely,
You know,
and that's all I'm trying, I shouldn't have said it.
No, but
Tried
true.
to for the record.
No, but true. We can, and I think
Absolutely.
intellectual discussion is very important.
So, Your Honor,
Just for the
the
record,
motion is still granted, Your Honor?
Granted.
Thank you.
just for the record, Real Water took no position on this, we just wanted to know what the ruling is.
Yeah.
Just make it really explicit.
I will do that.
So there's no misunderstanding.
Right now, we'll take copious notes.
And Your Honor, the plaintiffs will make an explicit order because we just want to know what the ruling is. We took no position. We just want to know literally if it's a ball or a strike. Whatever the court's ruling is, it is.
Video out. No causation opinions, no net cause analysis, none of that.
And press release as well? Your Honor?
Well, I'm gonna look at the press
Okay.
release. I'm gonna compare the press release to the other documents. I just wanna put it into context.
Yes, sir.
Now, I mean, that's kind of where we're at right now.
Yes, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. You got that, Tori? And the video wasn't in the papers, I don't think. But go ahead, that's fine, we dealt with it.
Yes, sir.
I'd rather deal with it now than for 30 seconds sidebar.
I think the next one's 26 from